Question for my next guest, who is from Attwood Marshall Lawyers. Please feel free to call us, 133882. Or, of course, you can email us, afternoons@4bc.com.au. We're talking about succession law today. The relationships, they don't always fit into neat boxes. People remarry later in life, get together, move in together without marrying. Maybe they form a de facto relationship. New partnerships, there is life after divorce. But when someone passes away, how does the law treat a relatively new partner? Does the length of the relationship determine whether that person is legally recognised under succession law? Today on Brisbane's Legal Lowdown, we're looking specifically at how succession law considers a new relationship after death and why it's not always as straightforward as people think. Welcome back to the program, Attwood Marshall Lawyers Estate Litigation Senior Associate Duncan MacDougall. Hello, Duncan.
Hello, thanks for having me again.
I had to read into a little bit about succession law and just what exactly it means here in Queensland. Very simply put, what is succession law?
Yeah, so it's really just when people think of succession law, they think of the wills, the power of attorneys, what's going to happen after you pass away, and really who's eligible to bring any sort of claim against the estate and who has rights to contest a will or say, hey, I've been inadequately provided for, and I am eligible to bring a claim.
And I guess that's the surprising thing for some people, that there is a minimum amount of time that you need to be in a relationship before you can bring a claim against your partner. Is that right?
That's right, yeah. So when you're talking about spouses in particular, obviously a married spouse will automatically have that eligibility as they're married. But when you're focusing on de facto relationships, that gets a bit of a gray area.
Sure.
But generally speaking, it's anybody who's been in a continuous relationship with the deceased for a period of 2 years ending on their death. But there's a number of different things that go into that, and they have to demonstrate that there was a genuine relationship there on a genuine domestic basis to establish that relationship.
What are some of those things? Because, if you have been married and you divorce, or it's a relationship you've taken up later in life or whatever, you might have established houses on your own and have your own, your own places. But you may have been in a relationship for, several years, but not have lived together under one roof. Is that one stipulation? What are some of the things that require it to be an actual relationship for you to take claim?
Yeah. So the biggest factor in all of it is, are you living together? So under one roof is going to be a big factor.
Sure.
But obviously things like, do you have finances shared? Do you have shared bank accounts?
Okay.
Are you on title with them under a property? Do you have children together? Is there... from an objective viewer of the relationship and other people in the community, do they view that as a relationship? All these sorts of things will go into it, and that dependency of one another, and things that would normally see as part of a normal spousal relationship, whether there was a sexual relationship, whether there was a shared mutual understanding of where things were going to go in the next few years, So a lot of things go into that. But in particular, it's really establishing, especially if you're bringing a claim against the estate as a de facto spouse, whether or not you fit that more strict criteria,
right,
of that, maintaining that relationship, because we do have issues where maybe they were in a relationship for multiple years, 5-6 years.
Yeah.
All of a sudden, nearing that 2 month, maybe a year prior to their passing, there was a separation.
Yeah.
They rekindle, or at least the spouse advises that they've rekindled.
Yeah.
But the rest of the family view it as, well, no, there was a proper separation there.
Yeah.
That's not a continuous period of 2 years, ending on the deceased's death.
Right.
So there's all sorts of things that can come into that, and all sorts of complications.
Well, it's kind of like long service leave. Yeah. If you leave a company and go back to them, that's not continuous service.
Exactly. Yeah, that's a way to think about it.
Okay, what about if someone dies and leaves the new partner out of the will? What legal options might that person have here in Queensland? It's different, I guess, for the rest of the country.
Yeah, so in Queensland, you've got that eligibility to bring a claim against the estate.
Mm-hmm.
But it's one thing to check the box that, yes, you're eligible. So that'll include spouses, including de facto spouses, if they can establish that de facto relationship, children, and dependents. But there's strict requirements under dependents as well.
Okay.
So. But as long as you can establish that, you've checked the box of eligibility, it's another then to establish that need for further provision. So that goes into, can I demonstrate financially that I need some more for my ongoing maintenance? So things like bank accounts will come into play, superannuation will come into play, whether or not you've now got a new relationship and their new spouse's finances will come into play. So it's one thing to be eligible. It's another thing whether or not that the claim itself is going to be viable or not.
I'm speaking right now with Duncan MacDougall from Attwood Marshall Lawyers. You're an estate litigation senior associate. If you want some advice, and it's general, obviously, if you want to give us a call, the 4BC open line, thanks to Watch Smoke Alarms, 133 Of course, you can email us as well, afternoons@4bc.com.au. If we don't get to your question, we will in the weeks leading up to this, because Duncan comes by frequently here for the Legal Lowdown on a Wednesday on 4BC afternoons. I want to ask specifically about superannuation. Who actually decides when someone will receive, superannuation of a loved one who has passed? Who decides that?
Yeah, so superannuation, it's considered a non-estate asset, so it's not an asset that automatically forms part of the pool of assets that's controlled by your will. So realistically, when you pass away, it's going to be the determination of, yes, you are a member of the fund, but it's really the trustee of that super fund deciding who's going to receive a benefit. So it's important to have that binding death benefit nomination in place prior to your passing, which binds the trustee of your super fund, whether that be Australian Retirement Trust, Q Super, etc., to make payment to those specified beneficiaries. Generally, that'll be the spouse, children. So when that's not in place, it creates problems.
Yeah, that's what I was going to say.
The estate itself could make a claim versus if we're talking about de facto partners. De facto partner could come into play as well, and it can then there's a competing need there. And really, it's going to come down to that superannuation trustee to make that determination. Now, when you've got again, superannuation, de facto partners in play here, where maybe you haven't established de facto on the strict interpretation of that on the succession side.
Sure.
Superannuation law is a bit differently. You've got a Superannuation Act and rules around there. So as long as you can establish that you are a dependent, or maybe perhaps even in an interdependent relationship.
What's the difference between a dependent and interdependent? Far out.
Interdependent is, I like to say, the girlfriend-boyfriend situation where there might not be a serious relationship there, but at least there's instances.
I like you more than friends, but not enough to...
and then we've already started to see some mix in terms of finances or etc.
That's the key here that I'm hearing a lot of, is that yes, your future may have been set for you, or you envisaged a future together, but things were happening that were practical, like finances were, started to mix and things like that.
And that just goes to the point of making sure you've got proper estate planning prepared prior to your passing as well. Especially if those relationships start to change, or the length of your relationships start to change, all of a sudden, the real risk is a lot of people don't understand when things can go really pear-shaped at the end. And it's really going to be more heartache and more costs down the line, rather than completely being aware of everybody's rights to either bring a claim or otherwise, or know the risks of your estate, and try to mitigate those risks now whilst you're alive, prior to that all going pear-shaped later on.
Because this is the interesting thing. We talk a lot, it's always in the news, about how it's more expensive when you break up with someone these days. It's more expensive to split your finances, and maybe there's a home that you share, whatever. So people are just living in situationships where they'll just stay together even though they're separated, because it's cheaper to do so, because the cost of living is so high. So it's too expensive to split. What happens there? It gets messy.
Well, it gets very messy. And I've had previous claim situations where on paper they're still married, yet they've been separated.
Yeah, that's right.
Provided that you're still married, you still remain an eligible person.
Yeah.
Obviously, there's a number of different factors that'll go into whether or not your claim is going to be worth your time and money to pursue, given the circumstances.
Sure.
But provided there was a separation there, but you're still on paper as a married spouse, that's a very important reason why, as soon as your relationship changes, go and get your new will done. Make sure you understand, or in this case, make sure you get that divorce finalized, because until that happens, that married spouse has a lot of rights.
Okay. Via email, Grace from Beachmere has written in. Grace asks, what happens if we have completely different accounts, independent investments, but one has more than the other? They've been together for a decade.
Yeah, and this goes into it. I mean, a lot of people treat these relationships more as a somebody to lean on, more of a companion situation rather than a strictly speaking spouse, and they may not have ever referred them to a spouse.
Sure.
But that being said, provided that we're only looking at accounts and only looking at finances, that's only one factor.
Sure.
That the court will consider. So unfortunately it's not one size fits all with these sorts of things.
Yeah.
There's a multitude of different things that they'll consider, depending on whether or not you lived under the same roof as well. If that's not the case, then strictly speaking, it doesn't appear that that's, as far as what I can hear, would constitute a de facto relationship.
Interesting. All right. I think that's all we have time for today. There's still plenty of feedback to come through. I want to say very quickly, though, if someone believes that they may have a right to bring a family provision claim, how long do they have to act in Queensland?
Yeah, so in Queensland, it's important to notify the executor within 6 months of the deceased passing of your intention to bring a claim, and then 9 months from the date of death to file your claim. There's certain exceptions to bring an out-of-time application, but to avoid that whole issue, it's important that those time limitations are met.
Okay, so not to drag the issue on, just to get onto it quickly.
Yeah.
All right, Duncan MacDougall from Attwood Marshall Lawyers, thank you so much for dropping by again, and I'm sure we'll see you very soon for the Legal Lowdown.
I'm sure. Thanks.